concluded that the bill should be interpreted as if this amendment were actually
my argument.
Well, most of the people that debated it argued that the bill should be interpreted as if this amendment were adopted. Now, if there's a court order, there's you really should not do a whole lot of original thinking. You ought to follow the court order, but the court order, as I understand it, is not an individualized court order telling each person what they ought to do. It's just a court order that the website is a bad website, and then everybody does what they think is right. If you go more than necessary, well, you got immunity because you're kind of following a court order. Now, one of the things about a court order and getting immunity with a court order is that a court order suggests that everybody's kind of had an opportunity to be heard. Both sides, both sides have been heard, and before you inflict pain on somebody, they had an opportunity to present their case. This is voluntary before any due process has taken place, and you're inflicting pain on people that may not have had an opportunity to be heard. Now, with this amendment, those who do not have this immunity on the voluntary action will just have to take do some reasonable due diligence before they take action, and then they'll be okay. Under the bill, they'll be okay. But without this amendment, they can do anything they want to anybody and fall within the amendment as long as there is credible evidence and they claim good faith. They ought not get immunity in a case where the victim of all of this really never had an opportunity to be heard. And I think fairness dictates that we require these people to have due diligence before they have immunity. And I yield back.
The gentleman yields back at time. Are there other members who wish to be heard? The gentlewoman from California, Ms. Lofgren.
Excuse me. I move to strike the last word.
Gentlewoman is recognized for 5 minutes.
I think the amendment should be approved. And one of the things about the DMCA is that there is a process for a counter notice. And as we discussed earlier in the discussion of Mr. Ice's amendment, this voluntary section, the vigilante section, there's no notice, there's no opportunity to be heard, and if there's anything that looks credible, there's complete immunity. Now, the opportunity for mischief is quite high. We think of the ISPs as separate from the content world, but that's not always the case. Say, for example, I don't want to pick on them, but I have cable TV. I have Comcast, and they also provide my ISP service. So there's a content provider, but they also have a business. I'm not saying they would use this, but certainly under the manager's amendment, they would have every opportunity to take action to disappear competitors if there was any credible representation made that they could rely on. The amendment being offered would preclude that opportunity because there would be notice, there would be an opportunity to be heard. As was mentioned by Mr. Scott, the argument, not certainly by Mr. Berman, but by many, about Mr. Ice's amendment was that it wasn't necessary, that the bill already provides for what Mr. Paulus's amendment provides. If that's the case, if that's what, I don't think it does, but if that is the belief, I hope that everyone who said that will vote for Mr. Paulus's amendment, because if that's what we thought we needed to do, this actually does that. I think that the opportunity to disappear competitors, to engage in anti-competitive activity is far greater than is being discussed here tonight. I think it's worth going back to say that infringing is not right. There is a need for remedies, but this provision is so much broader than is necessary to actually actively and successfully fight internet piracy that we really should take a look at Mr. Paulus's amendment. And I know we're all getting tired, but this is important stuff. I mean, the internet and the communication that it has facilitated is important. It's important to the freedom of Americans, and it's important to the opportunity not just for the internet world, but for the creative world to actually create and distribute. That's why the Writers Guild came out against this bill. I mean, I'm sure they got a lot of grief in Hollywood for doing that. But there's a reason why a free ability to distribute material is important not just to the internet but to the creative community. Mr. Paulus's amendment will preserve that, and I hope that we don't just reflexively say no. And at this I would be happy to yield to the gentleman.
I mean, I'm offering a number of amendments, but I do believe that this is the most important one to include in the bill to preserve any semblance of balance with regard to these laws. I am very open to the concept of an immunity provision. There just has to be, as I believe there is under the Digital Millennial Copyrights Act, there needs to be some check and balance under it. Any valid court order. And then, yes, if they are complying with that and some court has found that it is an infringing site, by all means take them down, and they shouldn't be able to sue you for taking them down if a court has said it's an infringing site. The question here is if no court has ever said it's an infringing site, and just some corporate counsel just writes something that even I could write that looks credible, and you don't know, the only thing you're going to do is just take down the site because you're completely immune if you do. And there's an unknown liability if you don't, because you don't want to adjudicate it. You've got a business to run. So, I mean, this is an extremely, extremely important part. This is could very well be the most disruptive part of this bill. I know there's a couple other potential fixes that if my amendment fails, I truly hope it doesn't, that Ms. Lofgren would offer. But I really call upon members of both sides to look very carefully at this. We have to fix this provision, or it would be extremely detrimental to companies everywhere. And I yield back the balance of my time.
The gentleman yields back the balance of his time. Are there other members who wish to be heard on the amendment? If not,
Mr. Chairman.
The gentleman from Utah, Mr. Chaffetz, is recognized.
Thank you. And I do appreciate this amendment. I think this is a critical component. We have to be responsible in making sure that there is a check and that there is a balance. Again, I recognize that there is a problem, but there should be a safeguard in which you must, and in this case, and help me if I'm not reading it right, but to go get a court, to get the court involved, it provides an extra step in the process, but it can be done swiftly. I think there are some people that are concerned that this would drag on for a year and a half or 2 years. I think this can be set up to be done swiftly, but would provide that extra safeguard. And I struggle to understand the argument against it. I think it is a reasonable measure. I think it would create that safeguard. We have to understand, these aren't, when we're talking about somebody's website, we're talking about their livelihood. We're talking about their First Amendment rights. We're talking about so many things that are core. And I also look at it through the lens and the purview of jobs in the economy. Now, certainly the content industry, they're developing music and movies and all, they get harmed if somebody comes and rips off their content. But also, if you have a malicious player, there should be a way to make that case swiftly. And I think this amendment would go a long, long ways to protecting jobs, the economy. You look at the United States of America, one of the few competitive advantages that we have in the marketplace right now is the technology industry. And it scares me to death that we're going to add this massive of bureaucracy and allow the swiftness that can be done on a single sheet of paper, and we're going to give all this liability and this real dramatic incentive to the credit card companies and others to swiftly take something down. We as a body, we as the American people, our Constitution and other things, we should be going out of their way to make sure that we protect people's rights. That we don't just have some bureaucrat, the Department of Justice, who just signs off on something and it just goes. And that is the spirit in which this is done. If somebody is breaking the law, if somebody is stealing, if somebody's... Of course we want to take care of it. But what Mr. Polis offers is a very reasonable step to make sure that there is a court involvement here. We are the Judiciary Committee. It's hard to believe we would argue that we don't want the courts involved. So unless I've got something wrong, I am in strong support of Mr. Polis's amendment.
Okay.
Yield back.
Gentleman yields back. The gentleman from Virginia, Mr. Goodlatte, is recognized.
Thank you, Mr. Chairman, and I speak in opposition to the amendment and associate myself with the remarks of the gentleman from California, Mr. Berman. He's exactly right. This is how the Digital Millennium Copyright Act works, and if every time any copyright holder or other business, I mean, I have a company in my district that you've all heard of it, Rosetta Stone. They make language things. They find sites every day, hundreds of them, that are illegally selling their product or counterfeit knockoffs of their product. And if every time they have to go to a credit card company and say, take down your credit card off of that site, you have to go get a court order, that absolutely won't work. It certainly wouldn't work under the Digital Millennium Copyright Act, and that's why you don't have to get a court order under the DMCA. This is a totally unworkable provision designed, again, to reduce the effectiveness of combating illegal rogue websites. And they're not U.S. citizens, they're not U.S. entities, they're not under the First Amendment of the United States Constitution. They're in other countries, and they're in those other countries because they're trying to avoid this reach of the law. And so we've got to make the tools available for U.S. companies to go after them workable. And that's what the bill does, and that's what this amendment would seriously erode. I yield to the gentleman from California.
I'm wondering, since you're drawing an analogy between the DMCA and this provision, whether you would support the counter notice provisions that exist in the DMCA for this.
Well, actually, in the original bill, there was a counter notice, and if a counter notice amendment is offered, I'd be happy to look at it. But that is a very, very different remedy than requiring a court order and all of the costs and actions that are entailed in having to go to get a court order every time one of these sites pops up. And for some of these companies, you're talking about happening thousands and thousands of times a year. That's why this provision exists, to try to get the various parties to this working together cooperatively. The companies that we're asking to do this, like credit card companies, they have every reason in the world to want to be able to have their credit cards used by their customers to purchase legitimate goods.
Will the gentleman yield?
I will in just a moment. They have a legitimate reason to want to make sure that they're not going to take something down unnecessarily. So if they rely upon the representations of a copyright holder or another business that says their patent or their copyright or their trademark has been infringed, and therefore they need to get a use of their credit card on a website taken down, they need to have some reasonable flexibility in doing that. Now, there is a counter notice in the DMCA, and if that is offered, I certainly would be willing to take a look at it, depending on how it operated and what effect it had. But a court order and all that entails and the cost that entails goes way too far, given the enormity of this problem for the companies that are attempting to do business on the Internet. I'd be happy to have the gentleman from Colorado.
Thank you. And again, if this, I hope this amendment passes. If it fails, we'll work with the gentleman to try to prepare an amendment for tomorrow that reflects the counter notice provisions of the Digital Millennium Copyrights. I would further point out that having different provisions for foreign infringers and domestic infringers is very much a anti-trade activity that other countries could retaliate on. To have one set of standards for our own and one set for abroad.
I don't know that there is a different standard, because under the Digital Millennium Copyright Act, which is what they're going to rely upon when dealing with U.S. companies, because U.S. businesses, U.S. websites that may be infringing are not covered under this legislation, there are those protections in that, as there would be in this, unless you raise the bar and make it harder to deal with foreign rogue websites than it is to deal with domestic sites, which would be the effect of your amendment and why I oppose it. And I'm happy to yield the gentleman from North Carolina.
I just want to say that I think the counter notice process is a fair compromise, to be honest with you. I actually thought we were where the gentleman's amendment And the way we got here is we started, the original bill had a bunch of no court procedures to it, and there was so much opposition to it that all of those things got taken out, right? And I thought we were left just with court proceedings. So I'm going to vote against your amendment, but I want to work, I'll be happy to work with you, because I think we really do need some balance similar to what we have in DMCA to make sure that the process is not abused. And so I'm sending that message to my friends across the aisle here. I just think, I think we need a countermeasure to make sure that people don't do things that are abusive.
The gentleman's time has expired. Are there other members who wish to?
May I ask unanimous consent for Mr. Goodlatte to have an additional 30 seconds that he might use?
I'll ask for 5 minutes, and I'll yield to the gentlelady.
The gentleman from North Carolina is recognized for 5 minutes.
I move strike the last word, and I'll yield to the
I just wanted to make a brief comment, because the suggestion that we're being tougher on foreign infringing sites than U.S.-based sites, I think is not correct. If you have a server in the United States and you are committing infringement, I mean, you can send in the sheriff, you can be arrested, your servers can be seized, you can be prosecuted and sent to jail. I mean, I don't think that's nothing. And to think that, I mean, that's why, I mean,
would the gentleman yield?
It's not my time, but I'm sure Mr. Watt would be happy to yield.
Let her finish, and then I'll yield to you.
I just think that it is legitimate, and there is a problem with reaching to sites that are beyond our jurisdiction. That, I mean, there's no quarrel with that. The question is how to do that, and how to do it without creating a situation where there will be certain to be abuse. I think that although when I asked the Department of Justice how often they'd actually proceeded to use the extraordinary remedies that they have, I was disappointed that while there's been seizure of sites, there's been hardly any arrests and almost no prosecution. So I think we may have a problem here in enforcement, not with the tools, but that the tools aren't being used in some cases. But as to the foreign sites, I think that the procedures outlined by Mr. Issa in his proposal certainly provides for an opportunity for an orderly march to a resolution that involves a complete elimination of funding. And I thank the gentleman
reclaiming my time. I'll yield to Mr. Goodlatte.
I thank the gentleman. I just want to say to the gentlewoman that I agree with her point about all the other remedies that are available to aggrieved parties when the infringing party is in the United States. And that's the point of this legislation. This legislation is trying to find some tools to reach the criminals who've left the United States or never were in the United States but see a great economic opportunity through thievery to set up these operations in places where we have very limited means of reaching them. And that's why this agreement, this legislation that provides a framework for companies to be able to work with intermediaries to protect them under circumstances, needs to have protection. The counterbalance, the counter notification provision is a counterbalance that I'm certainly willing to consider, as is the gentleman from North Carolina. But a court order would render this provision very ineffective. And the smaller the aggrieved party, the smaller the music company, the musician, the small manufacturer, the more likely they will not be able to avail themselves of this because of the added costs of this court burden that the gentleman's amendment calls for. So I oppose the amendment.
Reclaiming my time, I'm wondering if the gentleman from Colorado might consider withdrawing the amendment and increasing his leverage for the discussion tomorrow because you're probably going to lose the amendment, I think. But
I was
but
confident
think
I would win, but
if you still have the prospect of bringing it back tomorrow,
yeah.
And the prospect that some of us might support it, if we can't work out something, I think it'd give the gentleman more.
Yeah, and I just want to point of procedural inquiry, Mr. Chairman. If I withdraw the amendment, I retain the right to introduce the amendment later in the markup. Is that correct?
That is correct, Mr. Polis.
Okay, then I will withdraw the amendment. We will work on.
I'd be happy to. You got to initiate it. I don't want to draw it, but I think we need a balance here to keep the process from being abused, but it can't be just pursuant to a court order, I think, because that way, I mean, everybody will end up in court. I agree with Mr. Berman on that. So I yield back.
Okay. Does the gentleman yield back his time? Yes. The gentleman yields back his time. It's my intent, so that members may plan accordingly, to recess after we consider one more amendment. And so I don't know, in regard to... Wants to go fast. just one, yeah. It has to be a substantive amendment. I don't know what Mr. Scott or Ms. Lofgren want to do about their amendments, because I know they were waiting to see what happened on the Polis amendment.
Mr. Chairman, I had intended to offer 57 and 62 if Mr. Paulus's amendment was not adopted. Since Mr. Paulus has temporarily withdrawn, I think I should withhold and see what happens to that amendment. If it is not adopted in some measure that's satisfactory, I would offer those two at that time. But if it is satisfactory, then we would save the time of those two amendments. So I will hold those two off.
Thank the gentlewoman. And then what about Mr. Scott?
Mr. Chairman, it's my understanding that my amendment is identical to Mr. Polis's, so I just withdraw mine. I do have another amendment further down, number 40. We haven't gotten there yet.
Yeah. We will probably get there tomorrow, though. So I thank the gentleman for withdrawing his amendment, at least for the time being. That takes us to perhaps Mr. Chaffetz. The last
amendment I'd like to offer is an adjournment, President. That's not my last amendment, though. With all due respect, I truly would like to go tomorrow if I could, Mr. Chairman.
Okay, Mr. Polis, would you want to offer an amendment, number 36 and number 82?
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the Smith Amendment offered by Mr. Polis of Colorado.
This is Polis 82?
Pardon?
Polis 82?
Yes, sir.
Okay.
Page 46, after line 17, insert the following.
Without objection, the amendment will be considered as read. The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. This amendment would require the State Department to issue a report on DNS blocking, search filtering, and blocking payment processors and advertising networks. Again, when we're dealing with, and I have a couple of different amendments that we'll be discussing, I guess, tomorrow, and they deal with some of the reporting requirements under the bill in an attempt to make them more balanced. And currently, many of the reporting requirements, the studies that are to be reported to Congress, put in place criteria that are very one-sided. What this amendment would simply do on page 46 after line 17 is add to the Department of State report that after 2 years after enactment, the Secretary of State shall publish a report on the use of tools in other nations to block Internet access, including domain name blocking, redirection, search filtering, etc. There have been universal concerns addressed on this committee, and it is not an intended consequence of this bill that we would be preventing people in countries like Iran and China and elsewhere from accessing unfettered information. One of our most treasured national values is the right to freedom of speech and expression. Secretary Clinton recently said we all support a single Internet where all of humanity has equal access to knowledge and ideas. Unfortunately, this bill's inclusion of DNS blocking and search filtering has the potential to be a disaster for Internet freedom. While we were unable to succeed yet in passing an amendment that modifies the bill, and I personally hope that the bill does not become law, I think it's very reasonable for both proponents and opponents of the bill to have the veracity of some of these claims assessed through a report from the Department of State. My amendment would require that 2 years after the passage of the bill, the State Department, which already closely monitors these kinds of developments, such as internet censorship, would publish a report for the benefit of Congress and the public on the potential consequences of this legislation with regard to their goals. We should not, as a nation, stand for taking down, isolating, or censoring internet sites. And we need to point to legislation that supports free speech and allows for objective information to be provided to this Congress with regard to the ramifications of the legislation. Again, if anybody is even potentially scared of what is in this report, they should not support the underlying legislation. And for those who do support the underlying legislation, then we should have no problem with having a reasonable and fair report conducted by the Secretary of State for the benefit of Congress. I think that this would improve the bill. It's consistent with a couple other amendments I have in other areas that would simply make the recording requirements more neutral, and it would give the future Congress the benefit of information about the impact of DNS blocking on global free speech and the access to free information in authoritarian regimes, including Cuba, Iran, and China, to encourage the people of those countries to assert themselves and in their freedom of speech and freedom of discussion and political discourse. I'll be happy to yield to the gentleman from Virginia.
Mr. Chairman, I think this is a very important amendment, and I support it. My question to the gentleman would be, if in the private action, voluntary action, how would the State Department know? How would the State Department know that a website had been taken down if there's no public court order? If there's no, how would they find out?
With regard to their techniques, I believe, again, they already work on human rights issues on access to information abroad. I believe they are generally in consultation with advocacy groups and NGOs in these countries who would generally be aware of what is and isn't available on the Internet in those countries. They certainly don't have any superior or unique access, but they are on the ground in these countries, and they should be able to get a sense from their connections on the ground with regard to how the Internet is or isn't being censored.
Would the gentleman
yield to the gentleman from California?
I think this is a good amendment as well. I'm wondering whether this report might actually also encompass information in the other direction. For example, I mentioned earlier that the EU is actually moving in the other direction. I think it's interesting that they moved away from any kind of deep packet inspection or DNS takedown, just as we were beginning to review this legislation. And many think that they are positioning themselves to be the recipients of our Internet industries if this bill becomes law. I think that would also be a piece of useful information to have in terms of our economic competitiveness. But perhaps that's covered in your next amendment.
I deal with that in another amendment. I also would agree that it's not inconsistent with this amendment, and I believe that the Department of State would be able to, and perhaps with a letter supporting that of guidance if this passes, would be able to include that.
The gentleman's time has expired. The gentleman yields back. Recognize myself in support of the amendment. As I read it, and I know the gentleman described it a minute ago, but the Secretary of State shall publish a report on the use of tools in other nations to block Internet access, including domain name blocking and so forth. My concern with the amendment is that it would impose, obviously, a reporting requirement on the Secretary of State, and no one's consulted with the Secretary of State to see what they think about it.
Gentleman yield. Gentleman yield.
Who seeks recognition?
Right here. Right here.
The gentlewoman from Texas.
Mr. Chairman, I'm glad to hear you say that you would consider it and support it. I introduced a letter from the Secretary of State that was actually sent to Mr. Berman, and I think you could glean from the remarks here that the Secretary of State views the issue of protecting or preventing piracy as important as
Would the
internet
gentleman
freedom.
read the relevant excerpt from the letter?
I'd be happy to do so. There is no contradiction between intellectual property rights protection, enforcing and enforcement, and ensuring freedom of expression on the Internet. And it goes on to talk about the Arab Spring and the useful tool that the Internet is.
Yeah, I'm not.
Well, let me just say this. You won't have a sentence in the letter that says, I want to do the study, but what it does say is that they feel that the responsibilities of piracy and freedom are ones that they consider important, and I believe that you could assume that they would welcome the study that Mr. Polis is calling for.
Before I yield to the gentleman from California, I'm not sure that anyone can draw from that letter any indication how the Secretary of State feels about this amendment. The gentleman from California, Mr. Berman.
I don't really have an objection to the amendment. I have a very strong objection to the fundamental premise that a particular technology used for appropriate purpose is equivalent to that technology being used for a clearly shameful purpose. And that assertion that's been made off and on during this conversation and in letters to us, enriching uranium for the purposes of peaceful nuclear energy is not the same thing as enriching uranium for the purposes of producing a nuclear weapon. And the notion that the technology is what's evil, particularly since it's, at least as I understand it, a technology that we now use to deal with pornography sites and malware and spam, that's the evil rather than the purposes for it's used. But notwithstanding all that, let's have the report and maybe the Secretary will lay that out. So I'm fine with it.
Okay. Are there other members who wish to speak on the amendment? If not, I'll recommend that we accept it, and we'll go on and vote on it. All in favor of the amendment say aye.
Aye.
Opposed, no. The amendment is agreed to. I thank all members for their diligence today, for staying until 9:30 at night. We've basically been at it for 10 to 11 hours, and look forward to seeing everyone at 10 a.m. in the morning, and we will continue our markup at that point.
Until finished.
We will. I'm sorry?
Until finished.
And it's going to be a long, hard day tomorrow. Once again, 10 a.m. tomorrow morning, and we will recess until then.